Hello, hello, hello. Yesterday, I didn't know I could use the gavel. So today, the Chief Justice of Ghana has given me the power to use the gavel. Excellencies, distinguished professors, panelists, academics, and policy makers, ladies and gentlemen, good morning. Here in a very cold sub-zero New York, I salute everybody in this hall who braved the cold to be here this morning, and a big hello to everyone joining us online from around the world. Yesterday we had participants from India, from London, from Florida, from Nigeria, Ghana, Kenya, all over the world, so we are not alone here in conference room number 2. My name is Ben Dutse Malo. I'm a chief editor at UN News, and I used to be at the BBC in London. I am welcoming you to day number 2 of our 3-day academic conference on Africa, organized by the UN Office of the Special Advisor on Africa. And on behalf of the Undersecretary General, a strong Pan-Africanist, Christina Duarte, we wish to thank the distinguished panelists from yesterday's invigorating, thought-provoking, and brilliant discussions. We are thanking the Chief Justice of Ghana, Justice Gertrude Saki Tokonu. Professor Penelope Andrews, we thank you from the New York Law School. Professor Chidi Odinkalu, agent provocateur from Fletcher School of Law and Diplomacy at Tufts University. We say Diallo. And then our able moderator from yesterday, Professor Obiora Okafor of the School of Advanced International Studies at Johns Hopkins University. Put your hands together and let's thank them for what they contributed yesterday. Let me just mention, for anyone who missed yesterday's session or anyone who wants a recap of yesterday's session, the recordings have been archived and they are available on both YouTube and also on UN Web TV. You can go back and reference any key point you wish to get from there. Let me also add that we are welcoming papers on the themes and sub-themes at this conference, any write-ups. You just go to the website of the UN Office of the Special Advisor on Africa. And over there, you will see a place where you can make your papers available. Excellencies, today we have another great panel of experts, thinkers, thought leaders, and I will be introducing them in just a moment. The sub-theme for today is historical contexts and contemporary challenges, the evolution of rule of law in Africa. I must also add at this point that we are being fair to have both English and French interpretations. If you are here and you wish to just listen to French by your earpiece, please find the channel and you will be able to access the French interpretation. The same thing goes for YouTube. YouTube has 2 channels in French and in English. And for anyone who wishes to follow us live, go to UN Web TV, go to YouTube, and just search for Academic Conference on Africa. Everyone on YouTube can contribute in real time in both French and English using the chat box. Now, over the next 3 hours, we are doing 2 major things, ladies and gentlemen. We have the main panel discussion, and that will be followed by 1 hour of interactivity. Every one of us participating in this event has a voice. We want your voice to be heard, whether you are in this conference room or whether you are joining us anywhere from around the world. And so we have opened the channels. Make notes. When the time comes, we will ask that you raise your hand in the hall here, and those online, we will voice your questions to be addressed. Brothers and sisters, excellencies, distinguished guests, ladies and gentlemen, we are now going to focus on elevating the voices, the thoughts, and the wisdom of African academics in order to bridge the gap between these wise women and wise men and global policy makers. And our distinguished panel will address the issue of historical contexts and contemporary challenges. I believe they are bridging the gap between the past and the present. So let me now introduce the panel. First, Professor Zenandi Boy. She must be a cousin of a certain Nelson Rolihlahla Mandela. I just spoke to her. She's OSAA. I can't get the click right. She's an executive director, Center on Race, Law, and Justice, Fordham University School of Law here in New York. And then number two, joining us online directly from Liberia will be Chief Mary Latte. She is a paramount chief of Jokwele in Liberia. Next, we have Honorable Mr. Justice Professor Joel Mwaura Ngugi, a judge of the Court of Appeal of Kenya. And next, we have Professor Paul Tiyambe Zeleza, Senior Advisor for Strategic Initiatives and Professor of African Studies, Howard University. Also joining them will be a discussant, Mr. Henk Jan Brinkman, Permanent Observer of the International Development Law Organization, IDLO, to the United Nations here in New York. We will be hearing from them. And last but not least, a son of Kenneth Kaunda and Kwame Nkrumah, the moderator of this panel, Professor Muna B. Ndulo, Professor of International and Comparative Law, Director, International Legal Studies Program, Cornell University. Professor Muna Ndulo, I yield the audience in this house and online. They are ready for you and the panel. Thank you. You click the white button to your right there. Yes.
Good. Okay. Thank you very much for the introduction. I'd like first to take this opportunity to thank the Undersecretary General, Christina Duarte, for organizing this conference, bringing us together to share ideas and views about issues that are very, very important for our continent. I would also like to recognize the Chief Justice from Ghana. And I think maybe at this point I should just say I will observe all protocols so that I don't name and then miss others. So I'll end there. So I'm delighted to be here, and also thank you to the to Didi and the Maria Teresa for really the logistics. You've done a lot of work to bring us together. So our topic today is kind of broad, and I think we have to try and narrow it so that we can have an engaging discussion. And the historical context and the contemporary challenges in terms of the evolution of the rule of law in Africa. And I'll take it also meaning the evolution of human rights. Now, I think the historical context of the development of human rights in Africa is often discussed, as we saw sometimes yesterday, in the context of, whether it's a Western imposition or what. I take the view that we actually in Africa should claim ownership in terms of origin of human rights, because if you look at the history, and we are talking here about the historical context, really the nations that have been guilty of the grossest violation of human rights are Western countries. I mean, you take slavery, take genocide, colonialism, apartheid. Those were all Western invasions. So we have to claim ownership also of human rights, that we are actually part of that process. Now, clearly, in 1945, when the UN Charter was adopted, it clearly did not regard Africans as part of the people that we were talking about. And first of all, just the membership of the group that met to develop the charter, most of them were holding colonies, and the France, Britain, Portugal, these are the original states, and including South Africa. And in fact, even more interesting is that if you look at the documents in terms of the preparation of the charter, the human rights sections of the charter are actually attributed to Kruger, who was an apartheid prime minister, from South Africa. And there are a lot of, sorry? Sorry,
Closer, speak closer.
Closer, oh, sorry, closer to mic, sorry. I'm sorry. I was just saying that, of course, the origins in terms of the debates on human rights, if you look at the charter in 1945, the original states that developed the charter could not have, of course, included the third world, because many of the states that were the original states were at that time, in fact, holding colonies and denying human rights to millions of people in the world. I also try to point out that we in Africa should actually claim ownership of human rights. That is, it's human rights for everybody, because the West did not originate human rights. That in fact, if you look at the historical evolution of human rights, you will see that the grossest violations of human rights were actually committed by Western countries. And here I'm referring to slavery, I'm referring to genocide, colonialism, and apartheid, and many other ills. Now, clearly, it's also quite interesting that at the development of the charter, the articles relating to human rights in the charter are actually attributed to Kruger. That Kruger was the one who framed those articles, and there are various documents that authenticate that. And yet, at the time, he was actually from South Africa, the Prime Minister of South Africa, and clearly, again, shows you that that was not really the idea. Now, of course, we have gone through colonial rule, and the legacy of colonial rule is characterized by lack of rule of law, because the colonial system was not democratic and did not respect human rights. So it was massive violations of human rights. And of course, also, as was mentioned yesterday, economic devastation was one of the results. Now, we see that one of the things that I would like the panel to do, and I think will be my first question, will relate to the dreams, the expectations at independence. That, if you look at the independence constitutions, I mean, they inherited a legacy of lack of human rights. But the expectation and the hope was that, in fact, these societies would then be transformed. And that would be transformed and, become respecters of human rights. And of course, one of the questions I think we must address in this context, as our title says, historical context as well as existing challenges, is have the independence constitutions actually managed to transform the societies? Because we accept that these societies were actually undemocratic, lack of human rights, and the idea was transformation. And if, in fact, they have not been transformed, what are the challenges, and why hasn't this happened? And of course, here, in terms of the constitutions in Africa, I think we have two sets. You have the independence one, which in the common law jurisdictions are actually like Lancaster model, and they were very the same, whether it's Ghana, Nigeria, just the same. And then, of course, they were not really strong on human rights. And later, of course, we have the new constitutions that are developing in the 90s, the South African one, the Kenyan constitution, and all that. And the question still remains, what are the challenges of transformation in these societies? So that would be like my first question to the panel, and I would like each one of the panelists to address that question, the legacy, and then of course, what are the challenges in trying to change that, transform that legacy? So we begin with you, okay. Yeah.
Hi, everyone. Thank you very much. I'm very excited to be here. I do want to make a point of clarification that I am in no way related to Nelson Mandela. I am from Mthatha, yes. I speak Xhosa, yes, but I mean, not all Xhosas are related. And just to begin, I appreciate the title of this panel in conceptualizing the rule of law. It is very impossible to engage with and understand and to begin to respond to these contemporary challenges now I'm stealing from Professor Chidi, without rigorously interrogating the past. So much knowledge was gifted to us yesterday during the panel. And there's a lot of parallels to the discussions that we're going to have today and the discussions that were had yesterday. Professor Chidi made the point yesterday that the notion, at independence, the notion that we inherited an independent judiciary was a fallacy. And in not interrogating that fallacy and in not asking questions, we missed an opportunity to really come up with something new, to make a real change, and to conceptualize the idea of judicial independence in a way that actually responds to the needs of the various African countries that were coming to independence and creating new societies. And creating these post-colonial societies that we all wanted to see. So what I want to do today is extend the premise that he was making yesterday in relation to judicial independence and talk about the inherited legal systems as a whole, the legal systems that were inherited at the end of colonialism. Because these presumptions that we made from the conception that we have of the rule of law to how we understand and give content to the rights that we have and to the various areas of law that exist, from property law to contract law and to family law, we are told and we assumed that the premise of these imposed and inherited legal systems of Western common law and Roman Dutch law in the context of South Africa was sacred, and that we could only tinker with them by sprinkling in some of our officially recognized customary law, a customary law that was distorted and perversed by colonialism, apartheid, and their repugnancy clauses, and to adopt new constitutions, but then we shouldn't go too far, and we shouldn't be threatening established power institutions and power relationships. So this very generalized and summarized context that I've just given is really important if we're going to be engaging with how to respond to contemporary challenges to our understanding of the rule of law. Otherwise, we continue to perpetuate and entrench inequality, power imbalances, exploitation, indignity, and the denial of agency and humanity, which were all the hallmarks of colonialism and apartheid. Moreover, an important question that was raised yesterday, and I think will continue to be raised over and over again as we're having these discussions, is whose rule of law are we talking about? And other questions I would like to raise is that who is able to participate in shaping and giving content to that rule of law, whose language is prioritized in articulating our laws, in articulating our values and principles that govern and shape the societies that we're making. Who has the power and the legitimacy to understand, to interpret, to enforce, and to legitimize, to enforce and lay claim to the societies that we're creating and that we're shaping, as well as the protections and the remedies that come with the creation of those societies. So for me, the baseline of any society needs to be that everyone is ensured the ability to live in dignity, in safety, in prosperity, and in happiness. So in the societies that we are now creating with our understanding of the rule of law, who actually has access to any of those rights and any of those abilities. So to round off what I mean and to sort of tie it back to the question that we started this conversation with, when we think about the consequences of not doing the important work of rigorously interrogating the past and our presumptions of what we inherited, to ensure that we create these societies that we want to create, these post-colonial societies that we want to create. I want to sort of give a little anecdote of my experience as a law student many years ago when I was studying law at UCT. When we're thinking about how I was taught property law, the property law class that I was taught, we were only taught common law and Roman Dutch law property law. We were taught that these property systems are sacrosanct, that they were ordained by God himself. There was no engagement about where these property systems come from. There was no engagement about how they came to be our governing property systems and the necessary violence and erasure that was required to make sure that they were. It was the way it was, and it was right that the way it was, and there was no space to ask any questions. Moreover, it was never, in my property law class, not once was customary law and the property systems that come from customary law ever engaged with. Now, this is in a country that has a constitution that specifically recognizes customary law, that specifically recognizes the validity of property law that comes from customary law and the rights that are derived from those property systems. Oh, so in teaching customary law, those were all relegated to like sort of one course that's given to you at the end of your year. And sorry, just to conclude, like customary law then is specifically engaged with, where you're only given one course. 1 year at the end of your law career. It's a course that most of the students consider to be an absolute nuisance. They would have like intense engagements and debates with the professor at the time about whether or not it is a legitimate and an actual reality, and whether or not it could create legal obligations and legal rights. So these then are the lawyers and the judges and the policymakers and the lawmakers that then come to create and shape the rule of law that we end up sort of using again, and shape the engagement with our constitutions and shape how we're able to engage with all those things. So, I mean, to include, and I mean, this is gonna be a very long discussion, if we, at the point of departure, were engaging with our constitutions the way that we're taught to engage with as law students, and if we're taught and we continue to engage with them like that as lawyers, as policymakers, these challenges of responding to the issues that we're talking about here right now and creating very different societies is going to continue, because at the very basis, a different way of creating societies is not given any primacy, and the very same people who are taught the very same ways that were sort of used under colonialism and apartheid continue to be the ones that do the work of shaping and creating the laws that we live in. Thank you.
Thank you. So we'll definitely be coming back to you on some of the issues that you have floated. I would like to turn to Judge Ngugi here and ask the same question that, especially in the context of the 2010 Constitution in Kenya. So there's consensus in Kenya that, this is what we want to do. This is how we want to transform Kenyan society. And so accepting the legacy, which is, I think, what you've been trying to point out. So here we have a consensus that, so what are the challenges in trying to arrive at the goal? Because I think that there appears to have been a debate in terms of what kind of society Kenya wants to have, and that supposedly is reflected in the document which was adopted. So what are the challenges?
Well, thank you. And I probably should begin also by saying I am not Professor Ngugi's son, the one who spoke yesterday about speaking Kenyan languages, although we share a name. I'm very excited to be here, and I'm sorry I couldn't be here yesterday. I will try and pick up what was discussed. So what are some of the challenges? I think I really like what my predecessor has said. I think those are important points. I want to say I think one of the challenges is that we didn't have this kind of conference in 1963. Because probably that would have changed a few things. I think these kinds of South-to-South dialogues are important. They're important as a way of decentering the epistemic hierarchy we've had that comes from the North, that knowledge is produced in the North and then brought to Africa, and that's a lot of what my predecessor has talked about, really, in terms of how we understand these knowledges, these doctrines, even in the context of our independent constitutions. Now, the Constitution of Kenya, the Republican Constitution began by declaring that there is a republic, a sovereign republic called Kenya. So it was almost godly. So we don't know where that came from and so forth. Now, the 1920 Constitution, as you say, tries to remedy that by starting with "we the people." And then it's a very, of course, it was a very participatory document. A lot of Kenyans put their thoughts in it and so forth. But I would say, in the spirit of what we are discussing here today, is that we also have to be very careful that the old notions of how we think about how we govern our countries don't still stalk us, even when we have these radical documents. And I think that's what I heard my predecessor say first. I think some of the problems we had with the Republican constitutions we inherited was the framing of some of the questions that were put there. That framing can still come and defeat any attempts for us to have truly indigenous ways of rethinking and developing our societies. And I will just very briefly give three. In three examples. So I think, for example, we need to move from the notion of framing how we organize our ways of thinking about governance from what we now call just say the rule of law to what I think of as access to justice. So for many years, we have focused on rule of law and the traditions of rule of law, which usually has a very standard menu. That standard menu has not necessarily served us very well. And I think it's time that we moved to thinking about segmenting what that means and really ask, is everybody getting justice? Later on I can go into more about that because it's related to the concepts about alternative justice systems and customary law that have been talked about here. Secondly, I think we need also to move on from the concept of good governance, which is, again, a framing that we have used for a very long time, which, again, comes with a very standard menu, to what I think of as a concept of transformative constitutionalism or social transformation. And I think that has a more African relevance for us. And I think if we started from that framing, from that starting point, we could come up with very different ways about thinking about organizing our societies. And then lastly, and I'm assuming we're just setting the agenda and then we can come back to these ideas. Lastly, again, even the way we've thought about human rights, I think we have thought human rights in a very taxonomical way. We almost like as lawyers, when you think about human rights, we're almost always thinking about as morticians. We want to go to a place where human rights have been violated, and then we start categorizing them, taxonomizing them, and then saying we have now confirmed they have been violated, and what can we do about it? To a more forward way of thinking about human rights, I think about human rights more as social praxis. I think this is what is contained in our newly transformative constitutions. Where human rights, in fact, if you look at a constitution like Kenya, human rights, one of the articles begins by saying why we have and need human rights. And I think that's a very different way of thinking about human rights. It tells us we need human rights because it ensures dignity for all. We need human rights, it gives three answers. We also need human rights because it promotes social justice for all human beings. And then thirdly, it promotes the realization of human potential for all human beings and communities. I think if you start thinking about human rights from those three perspectives, we not only have the deontological Kantian idea of human rights, but we also have a consequentialist one about social justice and the realization of human potential, I think it can have very radical potentials for how we reorganize our societies. So I would also have to say, even as we have these transformative constitutions, we still have to really go back and change our software for thinking about them, so that when we have new software, then we are not giving back the same answers that we could have gotten from the old Republican constitutions, because the old ways of thinking about new concepts and new knowledges, and I would say, I think we've not done a very good job to think about the new knowledges that are coming from Africa, new thoughts about governance that are coming from Africa. We're not doing well enough to talk about our transformative constitutionalism. We're not doing well enough to talk about the ideas that are coming from our constitutional adjudication now and so forth. And if we did, perhaps we'll be going in a different direction. Thank you.
Thank you very much.
Yes.
We turn to you now, Professor Zelezo.
I want to join my colleagues by thanking the organizers of this conference for the opportunity for us to meet and converse on very important questions. So in terms of beginning with the first question, what were the expectations of Africans at independence? There were, of course, multifaceted sets of expectations. The late Thandika Nkandawire put it very well when he argued that African nationalism was really a humanistic and historic struggle for 5 key goals. One was, of course, political sovereignty and self-determination, so decolonization. Secondly, was, of course, the goal of development, which obviously had been denied under the colonial system. And then third was the goal of nation building. While these entities were put together, without obviously African consent, the peoples in those territories had to create nations out of the colonial contraptions of the state that had been created. So nation building was a key goal. And then, of course, there was the interest in democracy. By definition, colonialism was not democratic. It was authoritarian. And therefore, the struggle for Africans was for freedom, the ability to play a role in their own governance, to participate actively in their governance, which of course is part of the arsenal of democracy. And then, of course, the African nationalists were fighting also for unity across the balkanized colonial boundaries. So Pan-Africanism, regional integration was a key goal of nationalism. So these various goals of nation building, of decolonization, of development, democracy, and regional integration were critical. Ali Mazrui then added, I think, another important dimension, namely the struggle for Africa to become a global player rather than a global pawn. In other words, for Africa to achieve dignity and recognition, respect and dignity in the global concert of nations. Now, the challenges for implementing transformation within Africa, I think my colleague opposite me, next to me, has put it very well, that we have to, first of all, begin reconceptualizing, unpacking, or deconstructing a lot of the terminologies that we use. Notions of good governance, notions of human rights, notions of social justice, notions of transformative legal systems. What do they contain, and how can we make sure they embody African conceptions, African experiences, African aspirations? Now, some of the key challenges, and I'll just summarize because we'll have opportunity to talk in more detail, there are at least some of the following. One is, of course, obviously colonial legacies and legal dualism, which is a problem. State laws, customary laws, and so on and so forth. And then, of course, there are what Ngugi wa Thiong'o yesterday shared with us, language barriers, the dominance of European languages and using those languages for the law, and therefore sometimes excluding vast populations in our countries from access to legal discourse to the law. And then, of course, there are systemic inequalities, the ways in which gender, class, and ethnic disparities are deeply embedded in African political cultures and legal systems, and the implications of that. And then, of course, the whole question which the Undersecretary shared with us, the question of institutions, weak institutions, and sometimes corruption, how those affect the exercise, the execution, the implementation, and even the conception of the law. And then, of course, the marginalization of customary and indigenous knowledge systems in our legal systems. Of course, this extends to other realms of social and intellectual life. And then the issue of accessibility and inclusivity, the ways in which formal legal systems' reliance on technical legal jargon and inaccessible court locations and costly legal representation excludes the majority of people. And then the question of the balance between security and human rights, the question of environmental justice and resource governance. The Chief Justice from Ghana yesterday shared with us the whole question about land, how land is adjudicated, how land is distributed. And then the question of regional and international coordination, sometimes the conflict between national legal systems and norms with global and international norms. And then finally, we have to consider also the question of technological and digital divides, how technology is beginning to transform the ways we experience the law, including obviously issues of privacy and so on and so forth. I'll stop there.
Thank you very much. I think all three of you brought out very, very important aspects of this debate, the institutions, the dualism. So I think let's take one issue of dualism, because I think all three of you have mentioned this. Historically, of course, we all recognize that when colonial rule came, you had indigenous law, customary law was there, and the approach of the colonial regimes was recognition of customary law, but on conditions of repugnancy and all those other conditions. And then, of course, this dualism developed. So I would imagine that the African states, as part of transformation, would have been committed to developing one legal system. But very little progress has actually been made, in that area. Some countries have done better than others, but on the whole, the dualism continues. Even when African institutions are recognized, like chiefs and all that, they are operating parallel, to the mainstream administration. It's not really that they're integrated. So what is the problem, in terms of dealing with the law? There is need to reform the law, but what prevents South Africa or prevents Kenya or Ghana to actually develop a legal system that is inclusive and addresses every aspect, so that we don't continue to have this dualism, which actually in practice means that customary law is inferior. If you look at the way that it's administered, of course, I think some countries, like in Kenya, they're trying to do all this access, which is part of trying to address this. So what is the challenge about that? Oh, sorry. Sorry, we forgot our online participant, I think. Yeah. So who is making the arrangement? Sorry, we'll come back to
I am his junior brother to support him, so forgive me. We have online all the way from Liberia, a distinguished African woman, wise woman, Chief Mary Latte. And I understand she's online now. Chief Mary Latte, are you joining us from Monrovia live? Can we see you?
Yes.
Yes.
Yes, we can almost hear you. If you could send us some of the heat from Monrovia. New York is freezing, but the floor is yours, and Professor Ndulo will take up once you've made your contribution. Thank you.
Thank you so much. My name is Mary Latte, and I want to tell the conference thank you for inviting us to be part of this conference. I'm a female chief from Bon County, Central Liberia, and also Carter Center, thank you. Carter Center, thank you.
We are hearing you. We are using our earpieces so we can hear you clearly. So please go ahead. The technical men, we can hear much of what you're saying, but they will make things clearer. Please go ahead. Thank you.
Yes, I was saying thank you to you people to have me to be part of this conference. And thanks be to Carter Center through my son Johnny and the government of Liberia, also the African and the United Nations. The African rule of law, it has been good to us as people for the traditional Bible as a chief. From way back, other people ruled this country, the chief were this one that started ruling this country before Western people come. So in this ruling, we have been dealing with the rule of law, and we live with it. That's why have our community kind, and we're dealing with peace, we're dealing with justice, we're dealing with a lot of things that people will have in human right to see that we have peace here in the country. I think you can hear about King Boswell, we hear about King Peter Longway, a lot of kings were people that were governing this Liberia. And then we went to chief, clan chief, general town chief, all the way upward. And the alternative dispute mentor was one of the ideas that been brought to us that will settle and bring peace to us as people of this nation. And I feel that those ideas, for us as traditional people, sometimes to take matter to court, it will take us long, the farming system and other things will take time. So I feel that our way of life should be respected and also stand and be equal. We all should have equal opportunity in our tribes and in all the areas. Although all of the community within Liberia do not have the same tradition as we have. 11 countries have a tradition, a culture. But we got too many ways. Some people use Quran with different way of naming. We from the Chocolate Belt, like Central, Liberia, Ghana, we believe in peace, harmony, and also Quran. There are so many ways we have contributed towards this African continent. And then also looking at the law, when white people can things start to change, and we rule this land, no peace there, no trouble were there. We were doing it in peace. As Brandon saw when the chief sent messages, the messages go faster to the community dweller because they believe in us, and also looking down to our children. Because those issues, those children are down that they are the future leader for tomorrow. And then the rule of law, once we pass the law today, we are trying to clean the town, let everybody stay in the village today or in the chiefdom headquarters so that we can find a way to clean the town. You see more people, that law will be respected. And you have the town crier crying. If there is problem between two chiefdoms or two clans, everybody get together, we make peace just within a second. And I feel that that rule of law under the LDR, it needs to be fast tracked so that the community will be peaceful, so that our way, our dignity cannot go. Because that is the way we're born, and our way of life is different in life. And I come back to the system of the marriage system under the rule of law. Traditional people, we love one another when we keep up. We were growing up as women. There's a human reach society, and the man will come and work and know the value of that family before your uncle can turn you over to that family and say, this is my daughter, in the best way that you will be respected. So we are saying the rule of law is important. It should be implemented in all of the land and breadth of our country. And if it should work, it will work, and then we should respect one another in doing it. But the life now teaching our culture is still valued. And the way we were living is not too fun. The way we're living now. This is not the way we live, the culture was respected. We find a way today, we say we're having a culture dance, we're having festival, everybody will go there, have a fine time together, and then work, live together happily. But if the value go away from us, we will not find a way forward. And the culture, our way of life, the tradition, bring peace faster. Because we settle our problem on the Palabamos, we settle our problem on the Fola tree, and then we move on. And it is not expensive.
Okay.
So laws need to be respected. Thank you.
Chief Mary Latte in Monrovia, Liberia, I can see from your hand gestures, from your practice, many points you are raising. I'm from Ghana. If my family goes to my potential wife's family and they conduct a traditional wedding ceremony, should that not be enough? Do we need to go to church and do a European-type church wedding or do some kind of signing before our marriage is accepted? So a marriage between the academic or the European type of rule of law, Professor Boy says, whose rule of law are we talking about? So the marriage between the traditional system, where two chiefs can resolve problems easily, how do you incorporate that into this? Sorry, I'm trying to be an interpreter because I spent 2 years in Liberia. And just in case you were not, and because of the technical quality, I know many of us struggle, but I heard the words peace, justice, clan chiefs, respect, equal opportunities across ethnic groups, clans, and communities, and then respect for the powers of the chiefs, plus the marriage system. Professor Ndulo, I've done my interpretation.
Thank you very much, and thank you very much, Chief Latte. And I think your contribution actually comes at a time when we were trying to address this question of dualism, the dual legal system. So I would like the panel to, to respond to this, that historically, I think we all recognize that the colonial rule looked down on customary law, traditional institutions, and they passed laws which recognized the systems, but made them subject to English law or repugnance. Now, as part of the transformation, I think that we were expected to develop one legal system in Africa. And yet, this dualism has continued, and it's not an equal dualism. It's a dualism of one system, of course, being higher than the others. Even when we talk about the independence of the judiciary, we don't talk about the local courts or domestic, the other courts, independence of those courts and all that sort of thing. So what is the problem? Why is it that 60 years for most of the African states after independence, they've not done anything really in terms of addressing this question of challenge of integration of the laws. I think some of the presentations argued that, there's a language problem. They also inhibit access to justice. So what is the problem? So I'll start with the Professor Zelesa. We'll come from there, and then we'll go this way this time.
Thank you. I think there are a number of issues why legal dualism has persisted. One has to do with the fact that customary law is still relevant in many contexts. So that relevance of customary law, which reflects obviously the norms, traditions, and values of local communities, and in some cases seen as more relevant by certain population, persists. And then secondly, there is the challenge in a way it's a form of political pragmatism in which African leaders over the last several decades of independence have seen that maintaining legal pluralism in terms of customary law and others is useful for social maintaining the social order and stability, and obviously also concern not to antagonize traditional rulers who still hold a lot of sway in many contexts. And there is the challenge of resources. Reforming these systems requires a lot of resources which may not be readily available when there are other competing demands. And obviously it also reflects economic and power dynamics in society, in which customary law reflects and reinforces local power hierarchies that benefit traditional rulers who obviously will not give up that. And then the question of resistance, resistance to change. And in some cases, they're very compelling intellectual arguments for maintaining legal pluralism as a way of maintaining the diversity of African societies and acknowledging that diversity and mobilizing that diversity for promoting other arenas of concern, socioeconomic development, and so on. So I think there are multiple reasons: pragmatic, political, and even conceptual and resource based.
Yes, Jack Ngugi.
Okay. Chair, I'm going to ask for 2 more minutes to answer this question because I just happened, thank you. I happen to chair the National Steering Committee for the implementation of alternative justice systems in Kenya. So I naturally have a lot to say on this question. So just allow me, first of all, to begin by saying, well, first of all, it's good to understand why the colonialists started this dual system. And there was the colonial logic and there was the economic logic. Frederick Cooper tells us in his Gatekeeper thesis that, most African countries were systematically colonized but not systematically ruled. One of the colonial ways of reducing how much they were going to spend on Africans was just to make sure that we were not systematically ruled. That means leave the natives to their own devices. That was the beginning of the dual system. So it had an economic logic. That economic logic somewhat aligned with the economic logic of law and development. I know this is controversial for you, Professor Ndulo. But the alignment there was that African countries, when they came into being, they were ideologically committed to as much as possible reduce and probably wipe out customary law because there was a threat, I think as Professor Zeleza says, that they could form competing spaces for political power. So it became important that ideologically that they are reduced as much as possible. I think seeing it in that historical perspective is important, and I think it was important enough, coming back to Kenya. Kenyans saw through that. So in the 2010 constitution, Kenyans decided to move from that dualist lens, and I believe what the Kenya Constitution 2010 does is to come up with a rather complex and sophisticated a plural legal system. That's what it does. So in Article 1 of the Constitution, Kenyans give to the judiciary the monopoly of judicial power. But after having done that, they go on in Article 159, which is the one that tells us that the imperative concepts that the judiciary must use are transcendent. So basically the prime directives that the Kenyan judiciary must use. And one of them is unmistakably that the judiciary must promote alternative justice systems. So what we have on the one hand is Kenyans giving judicial authority to the judiciary, but on the other hand, giving it the commandment that it must promote alternative justice systems. Now, that's important to see because there are many other articles that Kenyans have put in the Constitution which makes it very clear that what they intended to do was to retain some judicial sovereignty to themselves, which would mean then what they intend to do is to only keep the judiciary as the default forum for dispute resolution. As a dispute forum, meaning that if two parties I have no other choice, then they will go to the judiciary, but they retain for themselves the right to go to any other forum in as many of their disputes as possible. Seeing it that way is important because Kenyans at the same time have told themselves in Article 11 of the Constitution that culture is the foundation of the nation. So these are not just articles that are papered in the Constitution, but you can see they are leading to a coherent whole. Then in Article 44 of the Constitution, they also give themselves the right to culture as a fundamental right, as a human right. So once they give themselves the right to culture as a human right, and then in Article 24, the right to culture can only be undertaken if, just like all the other fundamental rights, if you do a particular analysis which shows that there's a compelling reasons for you to take away that right. So the way I understand alternative justice systems is it's a cultural right. People have a right to choose how culturally they want to resolve their disputes. And if you're going to take them away from them, then you have to do an Article 24 analysis where you're saying, we are going to limit your right to decide your cases in this particular way. Now, if you look at it that way then, what this tells us is that Kenyans were very, very advertent about retaining their alternative justice systems. And a little later on, we can talk about why, because it's not a product of cognitive confusion. They were very clear about what they wanted. And then for now, I just want to put on the table the figures, because I think they somewhat help us answer the fundamental question that Professor Ngugi Othiongo asked yesterday about the role of law in, the role of language in culture, which I think goes back to your question. Because I think seeing Africans as choosing legal pluralism, I think it somewhat reduces the import of the argument that language as a carrier of culture, therefore, has this stranglehold on how we think and so forth. Now, when we did a survey in Kenya a few years ago, we found that only 17% of disputes are actually heard in court. So even if we were to take seriously the argument that, yes, language has a particular stranglehold on culture and how we think about culture and so forth, we're only talking about 17% of cases. 64% of cases are still heard through alternative justice systems. But even what is more worrying is that 19% of Kenyans have no access to justice. So this is the justice gap. So when Kenyans are saying, we want you as a judiciary to promote alternative justice systems, they are not only talking about the 64% of Kenyans who right now are getting their justice through these alternative justice systems, but they want the judiciary to promote it in such a way that the 19% of Kenyans who right now have no access to justice can get justice, because they're also aware that the 19% really are not going to be getting justice to be added to the 17% of the Kenyans who are getting their justice in court, because as courts, we're overwhelmed already with this 17%. We're always talking about case delays and case backlogs and so forth. So already the 17% of cases that we have completely overwhelmed us. In Kenya, we talk about backlog of 658,000 cases that are 2 years and older and so forth. So and that's only 17%. If we're going to add the 19% of people who have no access to justice, it will bring the justice system to a halt. So again, I believe the script that the Constitution of Kenya 2010 gives us is to rethink the question about access to justice and where people get justice. And if this was not obvious enough, in Article 48 of the Constitution, Kenyans tells us about access to justice, not access to courts. So again, they are very clear about what they the direction they wanted us to go. But even as we say this, even as we talk with Kenyans, especially lawyers and others in political positions, they still don't believe, despite all these facts I've put on the table. Mm-hmm. So maybe you can help us understand why, as a founder of Law and Development Movement. Thank you.
Sure that I'm a founder of Law and Development. So anyway, thank you very much for that intervention. So we come to you, Professor Boy.
Thank you so much. I think I'm going to build a lot on what Professor Ngugi was saying and what he was talking about. And I think if we're talking about why it is that our democracies, our constitutions haven't created the societies that we want, I think when we're sorry, I just saw myself on the thing, which was a bit jarring. But when we're talking about what the legal systems that we're creating and the laws that are being created, I think one of the parallels that I see in my experience working in South Africa that I'm seeing in this room right now, yesterday we were talking about how this conference is a convening of policymakers, of lawmakers, and academics, and I think a glaringly absent voice and a glaringly absent perspective are the actual people who live in terms of these customary laws, these traditions, and not us who study them, or not us who are administering them, or not us that are passing these laws, because these are the people that are actually, whose relationships are governed and are shaped by these laws, whose rights are governed and shaped by these laws. And when we're saying, how do we pass policies and how do we pass laws that recognize and see those people and how they live and ensure that they don't continue to be dispossessed of their rights to land, that their marriages are not being recognized, that a mine can come in and completely take people's land because the state and the law that we have does not see their rights, then we're going to continue to do it. Policy discussions and legal discussions don't include people that actually live in terms of these laws and understand these laws in ways that we can't even begin to really do so. And I think I really appreciated sort of the framing of dual versus plural, and sort of the difference in sort of not creating this hierarchy that inevitably sort of exists when we're saying, okay, cool, so now we're in legal terms, which the South African Constitution talks about. It says the highest law is the Constitution, and customary law is no longer subject to common law or to Roman Dutch law. It's subject only to the Constitution, and it needs to be dealt with the same as common law, and the rights that come from these systems need to be treated on par with one another, and we're not sort of creating this sort of hierarchy of legal systems, and we're not creating this hierarchy of rights and laws. But in practice, that's exactly what happens. And I think I'll use two specific examples in the South African context, and which, again, operate under the auspices and sort of this idea that we're doing exactly that we're respecting customary law, that we're bringing it in and we're having it help shape the legal systems that we have, when in actuality it isn't the case, and this hierarchy continues to be created, and people's rights are completely ignored and not seen by the law. And this is in the context of land. When we're talking, so in South Africa we have We have the Constitution saying rights to land or rights to property derived in terms of customary law need to be respected, as I was mentioning earlier. And when we're talking about people who hold rights to land in terms of traditional and customary systems, one of the seminal or the only law that exists is the Interim Protection of Informal Land Rights Act. And that's supposed to be a placeholder act that before we figure out how exactly we want to do this, we're going to use this and we're going to say people who hold rights in terms of customary law in the former Bantustans of South Africa, that their rights to land are recognized and that you cannot deprive that person of their rights to land without their consent, which is an important aspect that was never sort of recognized under colonialism and apartheid. You were removed and your rights to land were not recognized. So your property rights that you hold in terms of customary law are respected. But then how are those rights articulated? So they talk about occupation rights, they talk about use rights, and they talk about access rights. So anyone that has a law degree or understands ownership versus use rights versus occupation rights and versus access rights, you understand that even at the way that we're articulating and attempting to protect these rights, there's an immediate hierarchy. When we're talking about Western sort of legal systems, we're saying ownership. And then when we're talking about indigenous and customary and traditional legal systems, we're talking about access, we're talking about occupation, we're talking about, I forgot the third one I was talking about. So, but then there's like use, thank you. So there's already this hierarchy that is inevitable, and this is in a context where the Constitution itself says we need to be recognizing these rights. Now, every iteration of attempting to pass a law that recognizes these rights, the people who actually hold rights in terms of these systems are never in the room. And if they are in the room, they're not listened to. And that there's this assumption that we're going to bring legal experts, we're going to bring academics, we're going to bring all these things to come to these little meetings in Parliament or at the union buildings or in any of these spaces to tell the government, how do we make sure that we're not continuing to forcibly dispossess people of their land? And I don't own land in terms of customary law, and how is it that I am the one that is sort of has a higher platform and is considered to be more of an expert than someone who actually holds rights in terms of these legal systems? And we've already seen the extent to which attempting to make these rights look like Western legal system rights either makes them incredibly weak or invisibilizes them, or it becomes sort of useless and not responsive to how people actually use these rights. And practically speaking, it isn't practical to give everyone like title deeds. When you're talking about the fact that already with the 17% of people that bring these disputes to the courts are already overwhelmed. And then when we're talking about the Deeds Registry Office in South Africa, where was actually only created for the 13% of white people who could own land. So if we're saying that the entirety of South Africa and every person who holds any rights to South African land needs to go to the registry office and have their rights sort of registered there, and that you have to have this piece of paper, that again is going to collapse and it's going to be completely useless in the long term. So I think a huge problem is that a lot of our governments have continued in the approach of not bringing the people who actually have to live in terms of these policies and laws that we're passing, and making sure that they're an integral and not just, we're going to consult people once we have a completely drafted law and see what they say. And then when they say that this is a complete bastardization of how we actually live, we're like, well, you don't really understand because this person at UCT says that this is good. So I think that is a very important sort of point of departure of having to make sure that the people who should be shaping these laws and shaping the society are the ones that are very much the most vulnerable in these contexts and are able to do so. And then even in the, just in the last point I'll make is that even when we're talking about alternative disputes resolutions, South Africa has had the Traditional Courts Bill, which is a bill that has, that is supposed to recognize sort of traditional modes of sort of dispute resolution. Again, this bill has been considered for, I mean, I can't even remember how long this bill has been coming back and forth to be considered. And again, at the core of it is that we're trying to make traditional legal systems and traditional modes of sort of dispute resolution look like courts, or look like the way that like lawyers understand dispute resolution should look like. And the people who are actually using these dispute resolution mechanisms are nowhere to be found in the rooms that are making these decisions about what needs to be there. People are taken, they take a completely written bill and say, this is how we're going to do it, and it's in English. And if it is maybe sort of translated into another language, there is so much disjuncture between what the English version says and what like another language says that you can't really marry the two. So again, I think at the core of it is that we still don't respect Black people's agency and their ability to make decisions about their lives and to govern their lives. And if we continue to do so, we're going to continue to sort of have the situation where we're seeing the same issues being replicated and the same inequalities and the same indignities and the same lack of recognition of humanity. And we're not going to be able to sort of have this transformed society or these transformed constitutions have the impact that we want them to have. Thank you.
Thank you very much.
Professor Ndulo, just to acknowledge for those people all across the world who are listening to you and the panel, we have Dr. Philippa Idoho in Nigeria, Mr. Goodluck Eke in Nigeria. May the good luck rub off on all of us. Professor D.P. Sharma, University of Rajasthan in India. We have Dr. Gail Standback, SUNY Empire University, and we have a whole lot of other people online joining us. Back to you, Professor Ndulo, as we will be preparing 30 minutes more of the discussions, and then we will open the floor. Please make note of anything of interest, anything that provokes your mind, anything that you want to share, whether it's a question, whether it's a contribution that can solve Africa's problems and give us transformation, whether you are online in French or English in this hall, please get ready. We are about to go there in 30 minutes. Professor, I stole 1 minute of your time.
Yeah, no, that's fine. I think Chief Latte would like to come in.
Chief Mary Latte, in Monrovia, we understand you would like to join us again. Chief Mary Latte, we hope the technical qualities are better this time. Please, we are open to hear you, Chief Mary Latte. You must be in Monrovia. Over to you, please.
Thank you so much. I was looking at the community or looking at the law that is the rule of law based on the community that you form and the tradition that exists there. It should be written that what you have in your community should be preached, not something that is written by somebody, bring it over to you. You should know your way of life, what affects you, what you need, and what you don't want. Then they give you that feedback, then you get right on it. And then come back to, they say the rule of law for peace. Looking at peace is people that confide in you. You cannot go to a community if that community do not know, you don't know their culture and their way of doing things. Sometimes if you go there with some law, it will not suit them. So if the law that is given by, that is written by those communities will affect them, it will appear that if you tell them something, they will listen to it or go by it. That is why I just wanted to register.
We thank you. So the community customary law should be written or be given priority or preeminence. Over to you, Professor.
Yeah.
Thank you.
Yeah.
Thank you very much for that intervention. So, yeah, thank you very much for that intervention. So I think, we had very, very interesting interventions on this, question of pluralism. And I think it's time we moved to a related issue, which is institutions. And I think the Undersecretary General emphasized this yesterday, the importance of institutions. Now, I think as we discuss, just a brief comment, as we discuss the constitutions or laws, I think we have to realize that no law can implement itself. there's no such law. If you can get the best constitution in the world, it cannot implement itself. So it's the individuals, it's the institutions. And I think this really means that we have to look at these institutions. And I think as we discuss transformation, it has to go together with capacity building, so that they're both, just don't transform a society without capacity, and therefore it cannot be sustainable. So I come to this question of institutions. In what role do they play? And in terms of Africa, what role have they played in promoting the rule of law and human rights? And what are some of the shortcomings that we see? I think I'll start in the middle now with the Judge Ngugi, and then go to Professor Zeleza, and then Professor Boye.
Okay, so allow me to do what people do typically in these conferences, which is to ignore the question. First, just at the beginning. But I wanted to say something. Professor Boye said, I'm sorry if I massacred your name. Two things that I just wanted us not to lose sight of, and I will just mention them and then move to your question. First of all, there is the question about, which also comes from Chief Latte, about codifying both the institutions for African, for alternative justice systems as well as the law itself. What we've found in Kenya through the work we've done in my committee is that it's something that we have to be very careful about. And in fact, one of the things we studied was the South African traditional courts and the struggles they are having. And we had initially been asking when we were asked, when we were a task force, whether we would be recommending a statute, and we said not anytime soon. Because we do think that statutes do tend to distort, and probably African customary law should never be written. I think when you write it, you only skeletonize it. You ossify it. People start referring to it as some dead skeletal somewhere, and not as the real African customary law. The real African customary law is living. It's always changing. It's organic. It's plastic. That's part of the reason it survived so many years of colonialism. It has survived so many years of official denial that it exists and so forth. So I think we just have to be very careful about that. Then secondly, I wanted to say, I think if we are serious about the plural legal systems that our constitutions give us, and we put enough efforts in developing them, what we will start seeing is something very interesting. Professor Upendra Bakshi talks about, from India, talks about the concept of jurisprudence as opposed to, in relation to the concept of demoprudence. I think we have concentrated too much on jurisprudence, which tends to be doctrinal, which tends to be static, which tends to mainly come from the north. This is why our notions of property rights are really impoverished, because they're just informed by what we learned in that law of property in first year of law school and so forth. But if we allowed alternative justice systems to truly work the way they're supposed to work, which is they're really supposed to be in conversations with the courts, then we will start developing the concept of demoprudence. That is the wisdom of the African people that comes from alternative justice systems. And the way I think the Constitution is supposed to work is they're supposed to be in conversation with each other. It's not just the court influencing the alternative justice system, but it's the alternative justice systems also influencing the courts. And if we get that kind of a conversation going on, then I believe we start seeing different ways, imagining different ways of being in the world. To turn to the question of institutions, of course I agree. We must have the strong institutions, and those strong institutions must be must have people who have the right quality. That's both in terms of their learning, in terms of their attitude, in terms of how much they want to continue, in terms of how much they believe in the transformative power of the Constitution. For me, I would say those are the important qualities they must have. But they must take this a posture that learning is never complete, and they must just continue learning so that they can truly get to the extent of the transformation that our constitutions are capable of, and those that they promise us. But there's no question that institutions would be very important. For me, that's why I always welcome these kinds of places, which even as a member of the judiciary, I always say that when we have a south-to-south learning, it always works better because we can share solidarities and histories in ways that we may not get from traditionally going to, London or New York. I think when we go to Accra, we learn more. Or when we go to South Africa, we learn more, and so forth. So, thank you.
Thank you very much. Yeah. So, yes, Professor Varela.
I think there are two ways of addressing that. One is to underscore that there are different types of institutions that are actors in the transformation agenda, and that collectively all these institutions have challenges, as well as, of course, specifically, each one of them has challenges. So the key institutions include, obviously, the judicial institutions themselves, because they are obviously responsible for the execution of the law. And many of them suffer from, not all of them, obviously, lack of independence, sometimes corruption, sometimes issues of what we talked about earlier, accessibility. I was really struck by the 17%, and that 17% already overwhelms the system. And then, of course, that's part of the backlogs and so on. I remember when I was in Kenya, we had a land case which started in 2016. It's still not yet anywhere near adjudication. And then, of course, secondly, there are legislative institutions that are also critical in this arena. And sometimes their challenges include weak oversight powers, political dominance, elite capture. We all have learned from the South Africans the issue of state capture, which I think we should use it in many of our countries, including perhaps this one. And then there is the executive branch. And here, the challenges include authoritarian tendencies and corruption and nepotism, resource constraints, and so on. And then there are the traditional and customary institutions, also who are actors or players in this arena. And here the challenges include entrenched inequalities, lack of formal recognition, resistance to reform, and so on. And then civil society organizations. They are also critical players. And in fact, in many of our countries, they're the ones who have pushed the boundaries to expand conceptions of democracy and participatory engagement of populations. And these ones suffer from funding challenges, sometimes state restrictions. In many countries, laws are being passed or have been passed to make it more and more difficult for civil society organizations to be able to access funding, particularly if the funding is from abroad. And then, of course, sometimes fragmentation. In Kenya, for example, which I know a little bit better than other countries because I spent the last 6 years there, there are literally thousands of organizations overlapping. It's become a form of employment, actually. Then, of course, there are regional and international institutions, ranging from the AU to the UN itself. We're in the UN right now. Various, organs, ICC, ICJ, and so on and so forth. And many of these have limited enforcement powers and dependence on governments on national governments. And they also suffer from resource and capacity challenges. So if one was to summarize the key challenges that these institutions suffer from, obviously, one is weak institutional capacity. 2, political interference. 3, questions of corruption and mismanagement. 4, overlapping jurisdictions. 5, entrenched inequalities. And 6, the whole question of limited accessibility.
Thank you. I've been instructed to be brief, so I will endeavor to do so. I want to, again, I'm sorry, Judge Ngugi, I'm going to go back. I'm going to sort of touch on what you've been saying, because I see a lot of overlap. And I think the point that you were making about the problems of codification and the impact of codification. And again, I think as someone who's from South Africa, who continues to see what that does, what it does to try and articulate inarticulable and like very complex processes and ideas and values and guidances into sort of laws that then completely erase that complexity is again just continues to do what has always been done to particularly vulnerable people and to Black people. And I think this sort of this instinct to remove complexity is again ties into what we're talking about when we're talking about the institutions that are then tasked with implementing these laws, protecting these rights, because when power is so concentrated that everyone outside of that concentration is completely vulnerable and incapable of protecting themselves, then the failure of and the corruption of those institutions is particularly felt by vulnerable people who are then unable to protect themselves. And again, I'm going to go back to sort of the questions of land and the questions of alternative dispute processes. When your only way of articulating when it comes to disputes, because this always comes up when a dispute arises. So when it comes to a dispute, and the only way that you can articulate your rights to land, when a mining company comes in and says, we want to mine over there, who do we speak to? And then they're like, well, speak to the state and the chief, and everyone else doesn't really have any land rights, and all those land rights are subject to the chief or to the state. Then all those people then have no voice and have no ability to protect themselves. And even in the administration of sort of these land processes, when the day-to-day interpersonal way that these processes are governed is completely taken away, and a bureaucrat in Pretoria is the one that makes sort of the ultimate decision of how things are supposed to go, how is it that, and then that process is like a bureaucratic, there's so many people, so many decisions, so many forms to be filling out, that it collapses right down to the bottom, like, and then no one is protected. So I think this idea that we need to completely be empowering these institutions, leaving people powerless, is really why we're seeing a lot of the inequality, a lot of the exploitation, a lot of the dispossession that we're seeing right now, because people have no way of protecting themselves. Not that there isn't a value in a functioning state, that's not what I'm saying. I'm saying that there needs to be a way that people are able to actively participate in their lives and in the way that their lives are governed. And again, in relation to when we're talking about alternative processes and access to justice, when we're talking about the TCB and the Traditional Courts Bill, and the Traditional Courts Bill essentially the Traditional Courts Bill is essentially centralizing power in in chiefs, in traditional authorities, and completely erasing the families that are the first port of call in dispute resolution. When, like, a lot of the times how disputes are resolved in many communities is that it starts at the family, and it's only right at the end that it even gets to the level of even an Nduna or even a chief. So then when we're talking about how these institutions need to be speaking to the reality of people, is that we need to be empowering communities, and we need to be empowering people and recognizing what they're already doing every day and seeing a way of sort of making sure that they strengthen these ultimate sort of institutions, and it's not just bureaucracy.
Thank you very much. Yeah, I think that on the question of transformation and the empowerment and the capacity building, I mean, one would have thought that the institutions are already too much power. So what we're really talking about is capacity building in terms of individuals, in the society, that for them to be able to access justice, to do all sorts of things. I think I'll come back to the panel, give them a minute each to conclude, but I think we should go to our discussant, and we have Mr. Henk Jan Brickman, and he's a permanent observer of the International Development Law Organization, that's IDLO. He's a permanent representative to here. I think IDLO is based in Rome. So, and they do a lot of work in terms of rule of law. So over to you, I'll give you 5 minutes to make any comments that you might have on the deliberation so far.
Thank you so much. It's been really fascinating to listen to the panel, and I really learned a lot. Thank you for inviting me. I'm really thrilled to be here. 30 years ago, I started my career in the UN working on African issues as an economist, short-term forecasting and policy analysis. So it's a continent close to my heart. I think I want to limit myself to just a few points. Institutions, although that point has been made already, and I'm very happy about that because I do think they are really the crux. Gender and people-centered justice. So the International Development Law Organization really focuses on that every person in the world should live in dignity. And I want to second many people who have made the same point, and equality under the law. So that word equality under the law, I think, is really critical. So when I think Zenande said at one point, or asked, whose law or rule of law is it? It should be everybody's, right? It should be because there should be equality under the law. And that is so incredibly difficult, critical, but also incredibly difficult to achieve that. And I think, and this is one of the points I want to make is the issues that you discussed are, I think, really universal. There are so many of the issues with regard to access to justice, unequal access to justice, inequalities that are perpetuated, or systematic injustices that are not addressed or not resolved and are still perpetuating to this day. And it reminds me of when we were negotiating the 2030 agenda on sustainable development here in the UN, I advocated very strongly for a goal on peace and justice and institutions, but I was very much afraid that it would be perceived as like a northern goal rather than a universal goal. And I was very happy that there was very early on a decision by the member states that all goals should be universal. Each goal should be relevant for all countries. And it was really important that some of the developed countries were saying, we think this goal is very important to us because we have a problem with homicides in our country, and we have a problem with access to justice. And this is not just a problem that is limited to one part of the world or another. And I think that's really is really important in terms of the work of International Development Law Organization. And I think the word justice is really key to that. And it's not just about law, but it's also about justice, how people perceive these things. And I think we have seen a lot of discussions there lately, and I've heard the word colonialism a number of times, and we finally, I think, having some of these discussions about that. Long overdue, although we're still not there at all. But the issues of economic justice, social justice, gender justice, climate justice, racial justice, those are the issues that are really are very clear among the prominent issues among the people in the world. And one talks a lot about the decline of democracy and decline of the rule of law lately. But what is really striking is that the values of democracy and the values of the human rights are not really doubted by the people. The surveys of the Open Society Foundation, for example, have shown that. But what people are disappointed about is that they haven't delivered. They haven't delivered that economic or social or racial or gender justice. In South Africa, for example, 72% of the population would prefer an autocrat if he or she delivers jobs and reduces crime. So it's really about this delivery of governments, and that is what the institutions need to do. They need to be focused on delivering service to the people. And that gets me to my second point, and that is the people-centered justice. Institutions are important. We really believe that in IDLO, but they need to be reformed with a focus on people. What are the needs of the people? What are the justice needs of the people? What are the issues that are not resolved? There are apparently about 5 billion people in the world that have a justice problem that is not resolved. So in that regard, we really need to reform the institutions to make sure that the people who have a justice problem have access to it. And part of that is the customary and informal justice. I'm very happy that, of course, that came up a lot. IDLO co-chaired a working group on customary and informal justice, and we produced a report, Diverse Pathways to Justice, which if you Google that, you should be able to find that report, which really provides really important insights, not only to recognize the importance of the customary and formal justice, but also link it to the formal justice system when necessary, and make sure that international standards are adhered to, international human rights standards, for example, in particular with regard to discrimination against women. And that brings me to my last point, and that is with regard to gender. I have heard very few people mention the word women or gender, and I think it's a really important point. Kenya is blessed with an incredible Chief Justice, Justice Kome, but there are a few women in the justice sector, and judges or justices, but also paralegals, and that's what the customary and informal justice system comes in. Paralegals providing legal aid to women, and not only because they have specific needs, or gender-based violence is a huge issue, and we're doing a lot of work across the world on that, including in Tunisia, where we had recently a visit of 20 judges coming to the United States to learn from how other countries deal with that. And I think that's a really important point in terms of that these issues are universal. There's a lot of learning that can be done with regard to these issues that the whole world is struggling with. My final point is on gender is, and I'm here at the UN, and excuse me for having such a New York-based view, but one sign of this is the International Court of Justice, which of course is based in The Hague, but part of the UN system. In the 80 years, there have been 124 judges serving on the International Court of Justice. Only 6 were women out of 124. The International Law Commission, which is based, meets in Geneva and New York, but is a really important tool for the legal commission of the General Assembly to discuss certain issues before they come to the General Assembly. It has 248 members in its 75 years of existence, and only 10 were women. And I think we have made a lot of progress in many areas, and I think it's really as important to recognize that, including, I think, in Africa. And I want to recognize that point in terms of the norms and standards that Africa itself has set, including in particular through the Africa Union, but also through the regional and sub-regional organizations, such like ECOWAS. and putting pressures on member states with regard to adherence to the norms that they have set themselves. And one example is Gambia, for example, when the election was stolen, ECOWAS made it very clear that this is not acceptable and the president should leave. And I think that that norm setting is also coming to the fore on the international fora, where Gambia has really recognized a universal jurisdiction in many cases, and South Africa have brought a very important case of genocide in Gaza to the International Court of Justice. And that leadership is what we need. Thank you so much.
Thank you very much for that intervention, and also for emphasizing the issue of women. I must say, coming from Zambia, I feel quite proud that I think 58% of the High Court, Court of Appeal, and Supreme Court in Zambia are women. I think I'll give the panel just 1 minute because we're running out of time. Maybe two. Okay, 2 minutes each. We're running out of time. We have to go to the discussion. So please make your final comments on any issue that you feel you want to put across relating to this subject. So we start with you, Professor Bowie.
Thank you. I will keep it brief because I am excited to get to the point of taking questions and engaging with the audience. I think the crux of what I think in terms of engaging with the rule of law is really just being brave enough to do something different and not just asking and having conversations, but actually doing something different and adopting processes of doing something different and not perpetuating and redoing what we've been doing for decades that has continued to make people completely vulnerable and has not materially improved the everyday lives of most people on the African continent. And I think the discussions that we've been having right now, a lot of insight and a lot of guidance and a lot of value making can be taken from our traditional and customary and indigenous processes and ways of life, and giving that space and giving people who actually live in terms of those law space to be at the forefront of shaping our laws and our societies is really what's important. So being brave as a people and not letting ourselves get captured, which has been sort of what's always been happening.
Thank you. Thank you. And Judge Ngugi.
Yes, so probably all I'll say is I think from our conversations, what is emerging is that we need to reclaim that which is African and resituate it. For too long, we've accepted the framing that which is African, that which is traditional is necessarily irrational, or is devoid of human rights, or is devoid of values in a contemporary world. And we're saying that we need to reclaim that. Lastly, I also want to say that just coming to the question that Professor Bowie asked first, whose rule of law? I think whichever rule of law whatever conceptions now we repackage it in, one of what is clear is that the new rule of law, which we must reclaim for Africa as ours, must include at least notions of social transformation, must include notions of having credible mechanisms for sharing prosperity, must include notions of equalizing power, must include notions of providing constitutional justifications for government actions and so forth. Whichever notions of rule of law we repackage must include those at a minimum. Thank you.
Thank you. Thank you very much.
I've enjoyed being surrounded by lawyers. I'm not a lawyer, so I've learned a lot. You can tell from my remarks, I avoided mentioning any cases. So one thing which I think is important for all of us, while we recognize the challenges, the inequities, and the need to capacitate the legal systems and so on, we must understand that our society's problems are not going to be solved through the law. The law is extremely important, but there are other social, economic, and political dynamics and forces that we have to come to terms with. And we need to pay attention to them as closely as we pay attention to the need to change the law. So I want to thank my colleagues here for socializing me into the language of the law.
We didn't get a chance to get to the question of, we didn't get a chance to get to the question of knowledge, the contribution of Africa to knowledge and human rights knowledge and all that. But I guess we'll get to that another time. But I think it's significant to point out that actually, I mean, African jurisprudence has made significant contributions to the international human rights discussions. I mean, for example, the Namibian cases that went to the International Court of Justice, a tremendous contribution on issues of self-determination, but also discrimination, you know, the question of, and also the Rwanda Tribunal, for example, the question of definition of rape in the Kayesu case is very significant, which has been actually, copied by a number of American states, including California. If you look at the California definition of rape today, it's word for word from the Kayesu case in Rwanda. And of course, there's been significant, I mean, I think Professor Austin pointed out that he doesn't think that there's been any court in the world that has so contributed so much in terms of the debate of socio-economic rights as the South African Constitutional Court. I mean, many of the cases that are today cited worldwide are from that court. And of course, more recently, we had the Chagos decision coming up concerning Mauritius, with the, again, pushing the definition on self-determination and decolonization. So I think we've made tremendous contribution, but the question is how we actually capture this knowledge and project it to the world, because at the moment it's like we are sidelined completely in terms of knowledge production. So I take this opportunity to thank the panel, the excellent panel that I had. It was such a wonderful opportunity to be here and listen to the panel, and I thank each one of you for your incredible contributions. And I would like also to thank the audience for being here and also participating. So we now move to the next segment of this section. So,
could we please put our hands together and just thank the panel? I think at the BBC, I met a Zambian who taught me how to say Natotera, which is a Zambian expression for thank you. I hope I got the accent right. But we thank you very much, Professor Muna Ndulo of Cornell University. We want to thank every member of the panel. And by so doing, let me be specific and just say a big thank you to Chief Mary Latte, who joined us live despite the technical difficulties. Chief Mary Latte, everybody is clapping for you here at UN headquarters. You must be the hero of the day. Honorable Mr. Justice, Professor Joel Mwaura Ngugi, let's thank him. And the man who refused to quote any cases, Professor Paul Tiyambe Zeleza, we thank you. Mr. Henk Jan Brinkman from IDLO, we thank you. And special thanks to Professor Zenande Boy. I was taking liberties to associate you with Madiba. Whether you like it or not, all of us are related to the Madiba. Especially since one of the daughters is married to a Ghanaian. We can claim family links in that way. Ladies and gentlemen, a big thanks to Professor Muna Ndulo. Prof, thank you so much. Okay, now for the next 45, 50 minutes. My dear brothers, ladies and gentlemen, in the conference room here, online, joining us either through UN Web TV or through YouTube, whether in French or English, we've come to a key part. We want everybody's voice in this place to matter. We believe that you have something to offer, especially with these two words in mind, Africa's transformation, especially in the area of rule of law, justice, power, and the people. And so we want people in the room just indicate to the wonderful Ndidi who is going around that you would have a point, a comment, a question, or a contribution to make. She's taking all of them. We want to take as many as possible. Online, I realize that we have two people, I think ladies, Abigail Edu in Ghana sent us something, and then Kwadua Vanderpoy sent something that says, this academic conference on Africa 2024 and the UN Decade for People of African Descent, what are the points of intersection or connection? Where do they overlap? I believe there is something there. If any of the panelists want to draw the bridge or build the bridge between these two, Kwadua Vanderpoy sent that question from, I believe Vanderpoy is a Ghanaian name. So for those of us here in the room, raise your hands and then we will identify you and give you the floor. You have so much, okay. Over to you, Prof.
So I would ask the panelists to take note because you will have at least 2 minutes at the end to comment on the interventions. So the first number I have is 379.
Didn't turn, okay. Thank you. In the spirit of our ancestors, what a day this has been for me. And I'm just smiling. And the reason why, to our chief from Liberia, the tradition and culture impels us as African descendants, which Queen Mother represents 55 million displaced Africans here in the United States of America. I'm sure you heard in Ghana about 3 days ago or less than a week ago, over 500 went home from the diaspora to receive their citizenship. The time has come for us to go home. Queen Mother has crisscrossed Mother Africa in search of my roots, my tradition, and my people. And today you speak of the tradition and culture, which is the soul of a people, wherever you go in the world. And I ask this panel, are you ready in the spirit of Mama Winnie Mandela, who the young people said, Mama did not die, but she multiplied. And in that spirit of a great woman we loved here in the United States and in the United Nations, in her spirit and in Queen Mother Moore, who lived to be almost 100 years old, searching to return home. But what legal system should we be addressing to many of us who are gone to the Nile? The oldest kingdom is, you know where, in the Nile, of Nubian people. The king of Kush, or the kingdom of Kush, restoring many of the kingdoms in Africa as Queen Mother has crisscrossed Mother Africa and been installed in many of the kingdoms. What are you advising us to do from the legal system that we control as a people? We know about the other systems. And on the top of it, in any courthouse, even in New York City, in God we trust. We better trust God. It's no one else we can trust. So how do we forge the tradition and culture of human rights for a people? How do we do that? And I thank you. I don't expect you to answer today, and it's all right. But I thank you. I thank you.
Yeah, thank you very much. We will attempt to answer. So, 338.
First, I want to begin by congratulating the panel, distinguished moderator, panelists, and the distinguished discussant for an excellent and provocative and informative discussion. Just a couple of points, maybe three. I want to say that first and foremost, it's important for us to, and I know people understand this, but it's important for us to highlight the fact that these so-called traditional rule of law justice systems are not some museumified artifacts that we go and look at, right? And show to foreigners as native informants, right? These are our current modernities. Whenever I wear my red cap as a member of Ndins and Ozo of the Igbo people, I don't want anybody to tell me I'm wearing traditional wear. I am living my present, my modernity. Nobody tells an Englishman that he's wearing a traditional wear when they wear a suit. Are you getting my point? I think this is very fundamental, right? So I want to underline that. I also want to underline a point that I think Zenande and I think I can call him Joel because my old friend, he's not very old, but he's my old friend, Joel, made, which is about the importance really of looking to the bottom and the daily, quotidian practices of human rights and thought that accompanies it of ordinary people. How so important that is, right? I keep saying that there needs to be a greater, and I think Chidi made this point yesterday, marriage between anthropology and law and human rights, right? We still do not know enough. It is not true that we know enough about these daily, constant, quotidian, relentless, really struggles, because that's what it is, of human rights that ordinary people perform day to day, right? So, and to learn from that, right? And draw from that and create whatever we want to create out of that cloth. And lastly, just to reinforce the point that was made by the discussion about gender, and again to point out, as I often want to do, African great leadership on this matter that again usually lies in the shadows, is eclipsed, okay? The most gender equity international court in the world is the African court. There's no court that's even close. And again, very quickly, it did not happen by accident. Right. It wasn't like, let's leave it to the free market. You know, let's all go and compete, right? For the African court election, if there's a vacancy, first of all, there are 11 seats, 10 of them are zoned. There's one floating one. If there's a vacancy, say, from East Africa, and the sitting judge is female, the next one must be male. So you have almost 50-50 at every point in time. That's how it was achieved, right? So again, these are very important examples of deep thought, deep practices that are ongoing, that remain unexcavated, buried in the shadows and eclipsed, that we need to bring to the fore. Thank you so much. Yeah.
Thank you. The Chief Justice, 334.
Thank you very much. And I must add my voice of gratitude to the contributors who have provoked a lot of thought for me. Actually, since yesterday, I've been thinking about how do we reimagine access to justice? How do we concretize it? How do we ensure, especially for those of us who have the ability to do it, how do we do it? And do it with whatever resources that are available now. And in evaluating the question of whose rule of law, what rule of law, how we thread all the different strands of law, I could imagine easily how one can put together customary and informal dispute resolution centers around the country where the rules are in accordance with customary arbitration. The records are made available on the community level so that it's easy to access, it's easy to implement, it's easy to activate. And on the gender question, I would like to add my voice to how many times you see around the West African or the African continent, Chief Justice Kume of Kenya is a good friend of mine, and the Chief Justice of Liberia is another fantastic lady. And so Africa does, and I'm the third Chief Justice of Ghana. We started this journey long before I think the UK thought of of a female Chief Justice. And so there is much credit in gender mainstreaming positions within the policy space and the power space, especially where persons can make the most difference. But on the issue of customary law, I think that I already have one solution in my bag that I'm taking home, and I'm going to start working on almost immediately. So thank you to everybody.
It's going to come. Technician, please help Mr. Azuma to deliver with the mic open. 354. You have the power now.
The name is Seth Azuma, State University of New York, distinguished professor. I'd like to thank the panelists for your wonderful presentation. And I was here last year. The discussions have been life affirming. Yet, I am worried. Our keynote speaker, Professor Ngugi Wa Ntiongo, mentioned, and yesterday I was delighted he spoke in Kikuyu. By 1986, he wrote in English when he wrote about decolonizing the mind. And I observe our minds are still not colonized. We have continued these meetings over and over, and we continue to engage in prettification of scholarship to get grants, to talk about systems that are alien to us. Our ancestors were brought here because of property laws, not human rights laws. Because of property rights, our ancestors were called properties when they landed here. The question is, what do we have to do to take charge of property law? Because we continue masquerading, human rights are great, but we continue masquerading about those terms and those areas. When we talk about several $billion, when we talk about moving to electric cars, and Africans are not invited to the table, but the Chinese and Americans and the Japanese are there talking about the Congo and how to mine copper and blood cobalt. What do we do about property laws in those terms? So my question to the panels and anyone here is, how can we decolonize global hegemonies, including the nation states, institutions, and then give African agentic forces power to do what they can do, indigenous groups, autochthonous groups, to get engaged in the work that we do here. Thank you.
.384. The technician, there you go.
My name is Bakri Tanja from Mauritania. Thank you very much, panelists, for your insightful presentations. The question I have is this: to consolidate human rights, or the rule of law in Africa, how to deal with the issue of changing constitutions and the flow of the electoral process. You know, currently, very often, we hear about electoral coup. I can talk at length about my own country, Mauritania, where we had an electoral coup in 2019 and 2024. I heard in this room, the word, stolen elections. So when this must end? Thank you very much for your attention.
.358.
I'd like to first and foremost say a huge thank you to the panelists on the topic of the evolution of rule of law in Africa. I am Barrister Gorgia Damma Eze, Chairman of the Human Rights and Constitutional Law Committee of the African Bar Association, and member of the United Nations Committee of the City Bar of New York Association. Distinguished guests and speakers, human rights, rule of law, and democracy are indeed being challenged in this evolving era of military intervention, more particularly in the ECOWAS region. As regards the ECOWAS region and the military coups, there's a need for strengthening multilateralism, development, democracy, the rule of law, human rights in the era of military intervention. We're very much aware that recent global transformation, increasing geopolitical shifts, grave economic, financial, environmental, and climate changes have led to concerns on the potential for long-term stability, peace, and indeed sustainable development in the ECOWAS region. The leading question then is how are we to speak in terms of the rule of law in this era of military intervention in the ECOWAS region of Africa? It is hoped that with the will of the citizens, credible functioning of institutions will play a key role, not in only ushering in the desired democratic transformation, but also offering renewed hope for the future of democracy and development in the ECOWAS region of West Africa. Hopefully these gains and indeed collective efforts will serve as the building blocks to strengthen multilateralism in the pursuit of common global agenda and goals, more particularly as regards international peace, security, and prosperity for all. I thank you.
Thank you very much. I go to 357.
Thank you very much. My name is Charles Makunja. I work with the United Nations Development Program in the Regional Bureau for Africa. I cover the Eastern and Southern African countries.
Could you please just come nearer to the mouthpiece? We need to hear you loud and clear, sir.
Thank you very much. My name is Charles Makunja. I work with the United Nations Development Program at the Regional Bureau for Africa. I cover the Eastern and Southern African countries. I want also to commend the panel for very excellent discussions that they have brought together, but most importantly to thank the Office of Special Representative on Africa, for Special Advice on Africa, for bringing us together. I think this meeting represents what we call the triple helix model of innovation. And the topic is very important because it is coming at a time when the UNESCO General History is writing the next series of the chapters that were left, work that started in 1964. They are doing the chapter, the volumes 9, 10, and 11. And it speaks about the current challenges that we face, addressing, we already know where Africa came from, but now how do we confront these challenges? So this topic is very important, and I commend you for bringing it to us. I want also to observe that African experiences are diverse and different. And so there is no one homogeneous solution. And we have the current complexities of corruption, technological innovation, human rights abuses, and all these new challenges that are coming, which require nuanced understanding on how both historical injustices and modern dynamics can be addressed. As a practitioner, I work on issues of institutional strengthening, which you have mentioned, access to justice, which you have all mentioned. How do we, from your perspectives, help African? What solutions do you propose for the African nations to reconcile their historical legal frameworks with the contemporary demands for justice for all, but most importantly, accountability in our institutions? Thank you.
Thank you very much. I go to 335.
Let me join my colleagues in thanking all of you for your wonderful presentation. My question perhaps could be specific to the judge from from Kenya, Ngugi. And it goes like, it's a two-part question. If law is nothing but a rationalization of our cultural practices, to what extent is customary law not written likely to be seen as justice done? And B, going to my first premise, to what extent are the human rights challenges across African countries emanating from cultural practices that are alien to the continent and therefore needing a revisiting of the basis for human rights practice. Thank you.
(329). 329, yes.
Just before you go there, panelists, the questions loaded as they are for you. So take what share of the question you are going to address. Professor Ndulo will be coming to you. So you are taking all the load. Every question must be answered. Thank you, Mr. Okumu.
I alerted them of that already. Don't worry.
I also want to take this opportunity to thank the panelists. I just want to raise 3 issues, and I want you to throw some lights on. One is on the global justice system. The African justice system must always remain informal and inferior, to the extent that even when it gets executed, it does not limit one from being taken before the liberal justice system. How can this be addressed? In relation to this, when you look at the institutions like the ICC, which basically focuses on the liberal justice system, which is alien to Africa, especially now that Africa is prone to conflict. And African solution always relies around the traditional transitional justice processes, which basically has remained informal. In Uganda, we had to negotiate with the ICC to domesticate the ICC statute in order to use some of the traditional transitional justice processes to resolve some of the conflicting parties. How can there be an ICC without a focus on the transitional justice processes? Can Africa have an ICC which focuses at par, without inferiority, to address the transitional justice process? Secondly, I want to ask Joel, how do you see the emergence of regional courts? In East Africa, we have the East African Court of Justice. Is that a process towards transforming the transitional justice process? Because the colonialists never left regional courts, but we created them. How can that help to address some of these issues? And lastly, in trying to address many of the issues in Africa, there has always been sanctions on leaders, but at the expense of the population, which sometimes also undermines, it violates the right of the ordinary Africans to access food, education, and other services, because there is sanction, there is economic sanctions on African people, either because there's some disagreement with the leadership of these African countries. So how can this be addressed? Because this also remains a violation of rights of a people. If you sanction a country, you are subjecting the population to torture and suffering. It is not the leaders who will suffer. How can we address this within the framework of human rights for the good of the African people? Thank you.
Thank you. I'll go to 336.
Thank you so much to all the panelists, the excellent moderation, the CM, the discussant. This was truly exciting panel, and I'm going back with so many thoughts and questions as I ask my questions, which I hope all of you would respond to. So this binary distinction that we have between traditional versus modern, which is a question that Professor Okafor was alluding to, relegating the customary or traditional system and using that connotation of traditional by itself, there is a degree of colonist Eurocentric conceptualization in that connotation. Although Chalati Dirar has done excellent work when he looked at the customary law of Eritrea and Ethiopia to look at how the Italian colonial powers have worked to sensitize, erase local epistemic norms and laws. And I think maybe at a first instance, maybe we should move from that connotation and have a better wording to refer to our own systems. And then I want to push back on the question of codification. So that question of codification, I understand there are issues with codification because it solidifies the customary norms and practices, and sometimes that solidification could be narrow, but at the same time, it could be done in a way where it's systemic and it's a long-term project that acknowledges that it's a living knowledge and living tradition. And this has been done, again, in some parts of Africa, especially the Horn of Africa, Eritrea and Ethiopia. Historically, we've had this process of codification that is done in places where the Italian colonists could not reach, far away up in the mountains that they couldn't climb to, because whenever they get hold of those codes, they would burn them. And then the third point I have is there is inherent contradiction with the state getting involved, whether it's in the collection or adjudication by using customary laws. I'm even using customary, but our own laws and systems, because the state itself is a European or creation, right? The mapping of our nation states is a European creation that we have inherited from the colonial system. So could we possibly move on to think of broader ways, because those customs and norms that we are trying to implement within the European framework of the state actually sometimes transcend across borders, because the people live on both sides of the border, or on three sides of the border at times. So these are just thoughts for all of you to engage with, and you don't have to answer them, but just any thoughts you have would be appreciated. Thank you.
Thank you very much. I have, let's see now, 1, 2, 3, 5 more interventions, and we are running out of time. So may I appeal to the next 5 to be very brief. Otherwise, the panel will have no, sorry. Yeah, otherwise the panel will have no chance to respond because I'm informed 1 will be off. So the next is 417. 417.
Hi, I'm Zoe Gorman, a PhD candidate at Princeton University. Conflict and insecure environments have severely hindered the ability of states to deliver judicial services in several African countries. The absence of the state has led to sentiments of abandonment among local communities who turn to alternative judicial structures to resolve disputes and enforce these verdicts. Why do you think the perception of legitimacy of judicial systems has been particularly impacted in regions experiencing periods of rebel governance, more so than the perceptions of other state institutions? And how can states repair trust in the judiciary process among conflict-affected communities? And then a related question, the notion of human rights, which we've been discussing today, has in some contexts become politicized, and there's a perception that it might be an agenda of former colonial powers. How can we advocate for human rights that are for the people they are supposed to serve, and how can we perhaps update our understanding of what human rights means in these contexts?
So the 418. 418. Over there.
Yeah. Thank you. Joel Teku, researcher at Columbia.
I'm at Columbia Law School, a researcher.
We have in Africa is the natural resource and poverty. And one one of the root cause of these situations is mismanagement and corruption, as we know. So to solve this problem, we know that is the integration of civil society and indigenous population in the process of property rights on this natural resource. We observe that in many constitutions in Africa, we have some provision say that natural resources are still property of state. So my concern is how can we articulate these property rights of population and indigenous population in our constitution in terms to protect them, because we know that many state governments don't manage these resources. And the second point, and I finish them, is about the codification. We have country like Cameroon, who is a bilingual country. You have English, common law and civil law, and you have also customary law. And my concern is how a country like that can come with a unique systems who can address as well this issue of rule of state, because we have to navigate in these three systems, and it's a very complex situation. So thank you so much.
Thank you. We go to 353. 353. Over there. Getting work.
Yes, thank you. My name is Sheku Foyo. I run organizations in Africa, Sierra to be specific. Of course, I want to say thanks to the panelists for bringing up very important conversations, and I think we have learned a lot. I'm not a lawyer, but one of the key things that I want to make clear is that the Africa we all want is the Africa we all need, like part of our conversations yesterday. But how can we make our traditional law very popular? How can we ensure that we speak up, tweet, and ensure we use several platforms to ensure that laws that have been affecting our continent make it popular so the lay people can transform in our different languages so that they can understand the basic need. Of course, one key thing that is affecting us currently in the ECOWAS region is the coup d'etat. How can we ensure that we unite together as a continent and ensure we have peace access within the region? Thank you so much.
And you have 387. 387.
Thank you so much. I am a Cornell alumni. I tried to get into Professor Ndolu's class and I failed. I didn't fail the class, I just couldn't get into the class. And I'm also a University of Cape Town Law School alumni. And so I think we may have had some of the same professors, Professor Boy. But I am really interested in the panel's response as to what the likelihood they think for different African countries to sort of move towards what it sounds like Kenya started doing, something that breaks the legal dualism and tries to prioritize access to justice as opposed to access to the courts per se. I think that just like Professor Boy said, that people who live under the rights of traditional law and customary law, their voices aren't here, but I'm kind of wondering, like, what interventions or what innovations or what thoughts does the panel have for dealing with not just legal issues, but also political issues and also issues of business that might impact the way that people are able to engage with their own culture through the law. And I think my background right now is I'm here on behalf of the company I started, which is trying to codify, essentially, African history, primarily because I saw one of the libraries at the University of Cape Town burned down a few years ago, and I noticed that there were no Africans there to preserve their own history. Two people from England who were on holiday decided to volunteer to help us protect some of our own texts. And I think that a written way of protecting history is something that has existed actually in places like Mali and apparently in the Horn of Africa, independent of colonialism. So I think that there are ways in which it's just part of our history that colonialism has always been with us. We can try and innovate our own ways forward, and I hope we do, but writing that out of our history, I don't know if that's the wisest thing either. And so, yeah, I'm just sort of wondering, there are benefits to my mind to codification, which has been mentioned before, but there are also benefits to letting culture and tradition be like language. You know, language doesn't have to ask anyone permission to change, and I hope for that to continue. But I just would love to hear your thoughts. Thank you.
Thank you. Thank you very much. We have two more questions, but I think we are really running out of time. So unless, you can speak in half a minute each, or 1 minute, because the time we want 10 minutes, the panel won't have a chance to respond. So this is 389 and 361. Get ready to just make really a 1 minute intervention.
Distinguished guests and speakers, my name is Shazia Dausan. I was born and raised in Madagascar, and I'm a current student in international affairs at the New School, studying a master's. So what I wanted to talk about is that recently in my evolution of warfare class, I recently wrote a research paper on the Wagner Group. And as you may already know, it holds massive presence in African countries, specifically looking at casualties in Libya, Central Africa, Madagascar, and Mali. And they seem to be having very colonial tendencies. So my question is really, to make it brief and short, in terms of the rule of law and African countries' rule of law, how can we ensure that the Wagner Group does not overtake our power and our resources and our culture away from us?
Three, 6, 1.
Salam ለእናንተ ይሁን ስሜ ቤቴል አብርሃም ነው. For those who didn't understand probably what I just said, hi everybody, my name is Bethel Abraham and I just spoke in my mother tongue Amharic. As an Ethiopian and Eritrean, it's important to me to speak my language, and I think it was really riveting yesterday from the keynote speaker that language is important in a space of power like such. Thank you all for sharing your thoughts on this discussion on human rights. Yesterday there was a point made that research must make its way to the quarters of power, and I think it gives a good framing for what we touched on today on human rights and justice-related conversations. Two things kind of stick out, and I'll keep it brief, I know because we're short on time. The first is that our institutions necessitate capacity building, and noted by Justice Ngugi. 17% of Kenyans who are accessing the justice system formally are overwhelming the system, which is interesting to learn. Thank you for sharing. The second is that the need for decentralization of epistemic production. My expertise as a master's of public health student at New York University is in the health sector, but I would argue that health is a human right, and it wouldn't be justice or equity if it wasn't about people. And so I'm curious to learn from the panelists how you personally engage in decolonization and how you would advise us as future scholars and policy makers to creating a future of people-centered society in Africa without forgetting our past. Thank you.
Thank you very much for the questions from the audience. I'll now give each panelist maximum 2 minutes. It's like, if you can do it in 1.5, fine. But 2 minutes, because by my time we only have 9 minutes left. So we have 4 people speaking in 9 minutes. So we'll start with the professor.
Very quickly, obviously, in 2 minutes you can't. I think the Queen Mother emphasized something which is important, diaspora connections. We need to build them. The diaspora, the new diaspora is Africa's biggest donor. Last year it remitted more than $90 billion. It's not China, it's not the EU, it's not the United States, it's the diaspora. So let's strengthen linkages with the diaspora. The question of tradition and modernity, we really have to avoid putting these as epistemic opposites, because there is no modernity without Africa. The emergence of the modern world system was built on African labor, the slave trade, colonization, and so on. And historians, we tend to avoid posing these two as opposites. They're intermingled in very complicated ways, and Africa is part and parcel of the story of modernity. The book by Howard French, Born in Blackness, as well as the project by Nicole Hannah-Jones, 1619, shows you there is no Americas without Africa. There's no United States without Africa. So modernity is part of our story. The question of decolonizing the mind, I think there are 2 dimensions to that. One is mobilizing Africa's hard power, that is African states, African regional organizations, as well as African states, but also soft power, the youth, and the creative industries, from Afrobeats to Nollywood, to African philosophers, African intellectual production. All these are part and parcel of Africa's insertion into the global space. And then finally, I was very delighted to hear about the mention on the UNESCO General History of Africa, the 3 new volumes that are being produced. As you know, some of them, one of them is looking at global Africa, the diaspora, the very issues that we are all concerned about, and also revising our understanding of Africa's history in the 8 volumes, and pushing what Mazrui called the Global Africa Agenda. I think these volumes are not only important in creating new knowledges of Africa, but we also must move towards the translation of those knowledges into the school system across Africa, as well as, of course, in other parts of the world, including the diaspora, and the translation into policy.
Thank you. Judge Ngugi.
Ooh, so most questions were mine and they were technical. I felt I should have been given more time. Okay, that's okay.
2.5 minutes.
Okay. So the question of codification, of course, is a complex one. And you can see there are many questions that have been written about it. I think the answer I can give now is extend the thoughts that Professor Zeleza has had about modernity and tradition to this debate. The question is, why are we so anxious about codifying? Why are we so anxious about writing it down? What is it that makes us want to write it down? Is it an anxiety that if we don't write it down the way Africans have not written down things, it means that it's inferior? Is that really what we are fearing? What are we fearing? I think it can just be as complex, it can be as sophisticated, it can be as clear without writing it down. So we need to really ask ourselves the question, why do we have that anxiety? Is it out of, Cartesian rationality that has been infused somewhere in our, in our DNA that, because they wrote it down, we therefore must write it down, and so forth. So, what's in a name? That's an important question, again. So throughout, you would have realized I did not call it traditional, neither did I call it customary. I called it alternative justice systems. The reason I called it that is because in Kenya, and I suspect in many other African countries, I've seen the South African ones the same, I think the Zambian one is the same, the Kenyans put the judiciary as the default forum. They did it so consciously. And then, that's why I talked about Article 1, judicial sovereignty. but then told the judiciary, you are the default forum, but you must promote the other systems. So calling it alternative justice systems is promoting plurality without producing any hierarchy. In fact, the Kenyan Constitution does not say the courts have a hierarchy. They are just a default system. It's not hierarchically superior to the alternative justice systems, and neither is it a teleological journey. The Kenyans have not assumed that at the end of history, we will all become mini courts, or the more the alternative justice systems become like the court, they are better. In fact, the opposite is true. You are just as good getting your justice in your village. And by the way, I'm very happy. I get all of my justice in the village. Even though I'm a judge, I prefer my justice there. I think it's better justice, sincerely speaking. So there is no expectation that when we get a lot of money, when we become rich, we should have more courts to cover all the cases. In fact, the expectation is that we'll continue reducing the 17% and parceling it out to the traditional system. So it's not hierarchical, and neither is it teleological. Last one, state getting involved in this system. In fact, the schema we have come up with Kenya is there is no state involvement. The only extent of the state involvement is the judiciary promoting alternative justice systems, okay? So, but in terms of dispensing justice, the different typologies that we've come up with, in fact, one of the ones we have expressly said should not be, is impermissible under our constitution, is the regulated court system, where it's created by the state and people are employed by the state to do so. Otherwise, all the other justice systems where people constitute themselves autonomously to do their own justice is what we are celebrating. Thank you.
Thank you. And remember, we still have Chief Latte. So
okay.
2 minutes exactly.
Okay. I mean, so I think I'll put together a couple of the questions that were made in relation to modernity versus traditional, sort of using the language of traditional and customary, as well as sort of the question around how do we reclaim the notions of property and sort of center our systems in those discussions. I think, again, which is the point of who's having these discussions and who's in these rooms, because people are already doing that. People are already centering themselves and pushing for the recognitions of their rights. People are already making it clear that there is no distinction and there is no history in tradition, in customary, it is the present, and it is what we're living right now, and it is all the way of our lives. And there have been a couple of recent cases in South Africa where traditional communities and customary communities have gone to litigate the basis of their land rights on the basis of their customs and on the basis of their customary law, and not how, and using the Constitution and various laws to reinforce that, and not reinforce that this is how we're articulating them. But the way that they exist in our systems is the way that we want you to be recognizing them, and we want you to be protecting them against mining companies, against other forms of development. And I think, again, if we are having the right people in the room, then we're able to then bring the language aspect in, when we're able to describe what we're talking about, not in ways of custom and tradition, which with South Africa's history very much is about the fact that it is very seeped in colonialism and apartheid, how we understand these terms and how we understand these processes. So again, when we have the people who are actually a part of these processes and live in terms of these processes, all these assumptions that we have about language, all these assumptions that we have about modernity versus traditional will then start being challenged, and we will have to start engaging with them, not as sort of bygone era things or things that we only do when we're going to traditional weddings. Thanks.
I think we won't be able to go to Chief Latte because of the problems with the system. We're unable to do that, isn't it? That's what?
Yes.
Yeah. So we're able to do that. So I'd just like to thank the panel, this excellent panel. I'm really delighted to be with you and to chair this session. And also I'd like to thank the audience for really very, very good questions, and very that we need to consider as we go forward. Just one last comment, though, that I think as we discuss customary law, we mustn't discuss as if it's not contested, because on one level, we argue that what we have as customary law is distorted by the colonialists. At another level, we argue that that's customary law. So I think we still have to resolve those issues and proceed very carefully that it is self-contested, as to what actually is customary law. So with those few remarks, thanks very much. And once again, thank you to the panelists and thank you to all of you.
And please, if I could just excite you tomorrow from theory to action. You don't want to miss tomorrow morning, 10 o'clock is the final day. I am encouraging you, bring somebody along. I see Ambassador Ashraf as well. I'm looking at me, he's ready. From theory to action, leveraging African scholarship in policy development. See you tomorrow. God bless.